Welcome to another episode of the Heritage Month on Air series. Now, on the Heritage Month on Air series, both on Citi TV and 97.3 Citi FM, we bring you the historical incidents that have happened in our history as a nation and have carved the way to where we find ourselves today. Now, the Heritage Month on Air series is sponsored by Miss Cookie Spices. No peeling, no blending, just scoop and cook. My name is David Kwekusechi. We'll take a quick break. When we come back, I'll introduce my guest to you and we'll get right into the conversation.
Ago.
All right, so welcome back, and it's time for us to get right into it. And you've heard about the Bond of 1844, I'm sure. Well, historian Kweku Dako Ankra is going to tell us all about that, what led up to that, and what it is all about really, and how that has impacted our lives today. Welcome again.
Thank you.
Right, so the Bond of 1844, it's very popular. We hear it, we read about it and everything else. What is the Bond of 1844?
Also, the bond was a piece of agreement signed initially between the 8 Fanti chiefs who had gone to seek for interpretation of the abolition of the slave trade, whether it affects domestic slavery. And that, when these 8 Fanti chiefs they were cornered by the then governor, which was Commander Hill, and then he signed that piece of agreement with the Fanti chiefs on 6th March 1844.
I see. So what was it that, of course, abolition has taken place. They are wondering whether they can still trade and do business locally with in terms of the slave trade and all that. But what is it that, led to this whole movement to say, let's go and appeal?
So after the defeat of the Asante in the Akatamanso War, the British decided to have their food still on the Gold Coast. That's what, when we talk about the British attempt to have a jurisdictional authority on the Gold Coast.
Okay.
So in their mind, they intend to have a colony. So this started that after they have defeated the Asantes, they called for a treaty, and the Treaty of Formina in 1831. In this treaty that was signed in 1831, the Asantes were made to renounce their authority over every territory that under the British protection, which means from Accra all the way through Atong to Wassan and all those people to Axim, to Apollonia, Sechi. All of them are now under the British authority, and Ashanti has no power over them. So that was what the Bond of 1844, the 1831 treaty was about. In this treaty, the British also made it known to the Fantis who were also involved in this treaty that the British jurisdiction, legal jurisdiction, will be enforced within some of the territories. And so they created what is called Office of Judicial Assessor, who will create courts, and that courts will kind of hear cases with some of the African chiefs, and so that the British jurisdiction as well as the Akan or the native laws will be used in this law to try cases. So you see the double use, both the customary law as well as the common law. So when that was the first time we see the interplay of the common law and then the customary law being used to adjudicate issues since from the Treaty of 1831.
Okay.
I got in that point.
Okay.
So when this treaty came out, this treaty came out, then the British have started some sort of legal jurisdiction in the Gold Coast. And then...
But it was a peace treaty.
It was a peace treaty.
Okay.
Peace treaty that has taken Ashanti back home. They were supposed to, even under the treaty, Ashantis were supposed to pay 4,000 ounces of gold for the war. for as a war indemnity, just as they have been taking some from others.
Yeah.
They were to pay, but they negotiated, and finally they have to pay to about 600 ounces of gold, which they paid, and they were also to make some commitment. So after this treaty, and then the emergence of the semi-British jurisdiction in terms of using the courts to hear cases in tandem with the Akan native laws, this was allowed. So over the year, the British had in mind, from the 1831 to the 1844, the power that the company of merchants were arrogated to themselves on the Gold Coast was taken away, and the crown, British crown, took over for the first time. So when the British crown took over, Governor Maclean, who was the architect of the 1831 treaty, was appointed as a judicial assessor, whilst Governor Commander Hill, H.W. Hill, was brought in to come and assume the office from the 27th February 1844 as the governor of the Gold Coast, under the crown resumption of their power over the coast. So with this regard was the issue that was also agitating the minds of the Fanti chiefs. When the abolition of the slavery came, it was not really understandable to them with regards to having domestic slaves. We have the slave trade, which is the transatlantic slave trade, where you buy people and purchase them across the ocean to the overseas. But the domestic slavery is the kind of one where people have the servants and slaves in their house and they work for them. So they want to know if that was also affected by the abolition, so that they do not become corporates of the law. So they decided to go and then get the interpretation. When they went there, Governor Hill said, hey, wait a minute, you people have something even to do with you. But before you get the interpretation, this is what you're supposed to do. This is the document that I had as an agreement between the crown and then you, the Fanti states. So what happened? He brought these 3 pieces sentence legislation. One is that the people under the British jurisdiction, Her Majesty's forts and castles, must abolish human sacrifice, panyarian, and other forms of slavery. That is one. 2, they must also allow the British jurisdiction, as has been enunciated in the 1831 agreements, was re-echoed. Okay? And also, it is also a treaty of friendship and agreement between the British and the Fanti states. So this was signed on 6th March 1844. That is why our independence date was chosen by Nkrumah critically, because of the bond of 1844.
I see.
But the bond itself did not yielded any sovereignty power to the British. What it did was that it gave them some form of opportunity to create their legal system, because of their people were on the coast. And also people who have signed the treaty with the British to have some sort of British jurisdiction operating there. So McCarthy was able then to, as a judicial assessor, to hear cases from the governors, because the bond says that people under Her Majesty's forts and castles. So where the castles were, cases that occurred there were sent to the judicial assessor at Cape Coast upon the reference by the commandants of these forts and castles. So that is how the bond of 1844. So it started from the 6th March, from between 6th March to the following March, April, 8 more chiefs also came to join and signed the treaty, so that the British jurisdiction will be extended to them and also for protection. By December of 1844, many more territory African states on the Gold Coast have all joined, including Accra, Achem, and several other places.
I see.
So that is how the bond 1844 gives some sort of agreement between the British and then the Fanti state. But it did not yield sovereign right to the British as a for them to commence any kind of rulership or colony from that time. I get it that point.
I do.
So that is what happened. So from there, the British started to exercise jurisdiction, creating some sort of African corps and a troop of African soldiers. Whenever there's even issues occurring in the interior, they will send people there to go and take care of it. But they were not having that jurisdictional authority. Cases were mostly held at Cape Coast, where the governor was, or the judicial assessor was also there. So they put this army, some at the Asenomanso, okay, some also on the Cape Coast, Wasa, also some on Ejumako and other places. And as a result of these issues, also, Chief Edianan of Ejumako, who had been collecting the tributes, as well as Amankwa of Esukuma, all of them also came and sent agreement and relinquished their power under the British sovereignty. Under the Asante sovereignty. So this is the kind of thing that occurred with the Bond of 1844. So the Bond of 1844, indeed, people have made it look very critical, but the power of that jurisdictional authority apparently flowed from the 1831 Treaty of Famina, because it was there. What the Bond of 1844 did was the re-echoing of that initial power given to the British to hear cases under Her Majesty's forts and castles was repeated under the Bond of 1844.
All right, we'll take a quick break at this point. When we come back, we'll get more into the Bond of 1844 and the ramifications after that. Till this point. All right, welcome back. We're talking about the Bond of 1844 and the incidents that led up to it. And historian Kweku Dako Ankra has been giving us all the details. Now, Kweku, so you said that the initial treaty was the peace treaty of 1831.
Yeah.
Then, of course, there were other things that had happened in 33 and so on and so forth, leading up to the 44, the Bond of 1844.
Yeah.
Now, what did that really do for us as a nation, 1844, in terms of our relationship within ourselves, that's among the Ashantis, the Fantis, and so on, and other groups? And then what did that also do for us internationally as a whole, you know?
Yeah. So what happened was that the Bond of 1844, following its signing, gave some sort of relief to the southern coastal communities, as well as those in the interior who have now taken away from the power of the Asante. So for the first time, Asantes are not taking tributes from them. They were not enforced by Asante diplomats, those who have been placed there to enforce Ashanti rules in the community, as well as other extra judicial activities that affected the people in the community. Because some of the Ashanti diplomats or the resident diplomats were really also exhausting and taking taxes from some of the communities they were in. And this created a lot of frictions that were sometimes often causing rebellions or bringing Ashantis back and forth to the coast to come and reinforce their rules and regulation and so on. So what this the Bond of 1844 did was that it offered the British opportunity to use that agreement to expand their jurisdictional control over some of the Gold Coast territory step by step. Okay?
How so? Because in my understanding, you're signing a bond to say we will be of good behavior, we will no longer go and be catching slaves, we will no longer be, terrorizing people and so on and so forth. How did then that allow the British to expand?
Yeah, so what you didn't add was the jurisdictional power that was flowing from the bond, which was, I explained earlier, was the re-echoing of the 1831 treaty. So that jurisdictional authority is legal. That gives them opportunity to create court, which means cases will no longer go to the chief's court, but it was going straight to the British. So the British rule or British laws are now operating in the Gold Coast.
Okay.
And in order to give more British power, it means to undermine the local native laws
Yes.
and enforce more of the British laws.
Yeah.
And so that is what McCarthy did. So by 1851, James Bannerman of Accra sent a communique or a dispatch to England where he complained about the fact that the new governors that have come have undermined the role of the chiefs, the native chiefs, in the administration of the native courts, which was supposed to be between the British laws as well as the Gold Coast laws. His comment was also supported by Henry Swansea, who was also a British trader and a former magistrate in Maclean's court, who also stated that indeed this move has been done to undermine the native laws just to enforce the British laws, and it was at variance with the original ideas carried under 1831 treaty as well as the bond of 1844. And so therefore what he was at pains with, because Swansea was married to a Cape Coast woman, was that the Coast Coast chiefs were not even complaining, and this had led to this flagrant abuse of their right in tandem with those the dual application of the law for the betterment of the Gold Coasters themselves. So this went on. So by 1853, okay, then the British, in order to enforce their power completely, came out with a Supreme Court of Gold Coast in 1853. And this time it means they were taking center stage legally. And then they appointed a governor who was a judicial assessor at the same time, and then also appointed judicial assessors who were at the same time Supreme Court judge. And then this gave the room for the emergence of the British legal framework to start operating in Gold Coast, undermining the native laws and then rolling out fully the framework of the British
So in
law.
a certain sense, the bond of 1844 actually came to diminish the powers, the local powers that we had in terms of taking care of our own, you know, our local politics, our local justice system, and all of that, allowing the British to spread further.
It didn't at all. What it says is that the power was given to people who were residing under Her Majesty's forts and castles.
Okay.
So it was only to them.
Along the coast.
Very good. That
Okay.
is why King Agri of Cape Coast used that thing to disrespect the British courts.
Okay.
And he still kept his court, and then he had the friction with the British colonial authorities, and he was exiled because his argument was that the bond of 1844 stated that under Her Majesty's forts and castles, and where his palace is and where he rules
was there.
it was not under the Her Majesty's fort and castles. So that
so he
should deal
could-
with its
okay.
own. He will also have his court.
Okay.
Because that is what the law states. You cannot extend it beyond
Okay.
where Her Majesty's forts and castles.
Okay.
So so if you look critically at the formation of the Supreme Court in 1853, it states that it was a Supreme Court of Admiralty. So it was going to deal with British people who have claimed to be the subjects of British. So there was a famous case where there was a Jamaican attorney called William Finlayson. He had a fancy clerk called Wood. Wood had gone to do something wrong and has been arrested by the Cape Coast Omahen's court. And the Omahen's court has fined him.
Yeah.
And he told Finlayson, and Finlayson wrote to the Cape Coast Omahen that you have no jurisdictional authority, for the guy is a British subject. You see where the differences came?
Yeah.
So why would the Cape Coast Omahen's court find Wood, who is a mulatto from Cape Coast, that he is a subject? But Wood is also claiming, no, I am a British subject. So you see the contestation that all these things brought.
No, but you see, that's why, this is why I am saying that it then challenged our power. you know.
Yeah, it challenged our power because the British used dubious means to extend
their influence.
A power or influence they don't have under the two treaties that have been signed. They use it as a pretext to expand because some of the people, because of the protection from Ashanti, were willing to allow these rules to take place. So as a result, that is why we have our first Gold Coast attorneys, self-taught attorneys, where so from that period from 1851 going up to 1864, the 1864, the Supreme Court, they came out with rules that even people who were practicing as self-taught attorneys should register. And we had about 7 first Gold Coast people who started practicing law. So if you go to the history of law on the Gold Coast, you will come across James Attenborough, Charles Bannerman, and all those people. Charles Battels of Elmina, you have George Kuntu Blankson Jr. So
they were all self-taught.
Oh, they were self-taught. These were people who have learned, but only James Attenborough was the one who had gone to England and learned some sort of solicitorship. So when he came, he had that opportunity and he was granted the license to operate. So the rest were people who were knowledgeable and they were using their knowledge to actually operate the law. And they were even very good until someone particular British magistrate called William Packer came and started dealing with some of them, arresting some and taking away licenses. And that led to a lot of issues. And later on, by 1866, they have started reissuing it back to these self-taught attorneys until the Supreme Court ordinance of 1876 created proper Supreme Court system in the Gold Coast. And for the first time, we allowed the professionally taught barristers who have been trained in the Inns of Court to come in. So you see in the Gold Coast by 1877, the first professionally trained Gold Coast lawyer was Thomas Woodcock, who was a British Antiguan, who came in to start the practice of law as the Queen's advocate. From there, in the 1888, we had the first African who was also practicing on the Gold Coast, who was Christopher Alexander Shapara Williams of Nigeria, who came in to practice after there was James Maxwell Renner Maxwell, who was also a Sierra Leonean, but whose father was a chaplain at Cape Coast Castle, also coming in. So we had a series of some of these Africans until the 18th person to qualify as a professionally trained lawyer, who was a Gold Coaster. That is John Mensah Saba, who became a lawyer and barrister in 1877. 1887 as the first Gold Coast lawyer.
Fantastic. So let's track back a little bit. So again, the bond of 1844 was signed on the 6th of March, 1944. This is the reason why our Independence Day was chosen as 6th of March.
Yes, for many people, it was the time that piece of legislation, which cannot be what Edubuayin described as, cannot be described as a Magna Carta of the Gold Coast. It cannot be signed as a bill that really signed an agreement and the Gold Coast reneged their rights and gave the British authority to operate. Was not there. As I said, it was not there in the first place. So many legal historians like say Akuko St. John, Saba, Kesley Hayford, including Dankwa, have all argued that there was no jurisdictional right given to the British in the bond of 1844. But what the British did was that they took advantage of the small jurisdictional power given to them under the Her Majesty's forts and castles to expand their right by creating the Supreme Court of Admiralty in 1853 and moving on with it.
All right, fantastic. So that is the conversation we've been having about the bond of 1844, the things leading up to it, and the fallout of that bond thereafter. This has been another episode of the Heritage Month on Air series. And of course, the Heritage Month on Air series on Citi TV and 97.3 Citi FM is sponsored by Miss Cookie Spices. No peeling, no blending, just scoop and cook. My name is David Kwekusechi, and I want to say a big thank you to Nalem Clothing for this beautiful top that I have here. And we'll be back on another episode of the Heritage Month on Air series.
Ago.